Hello there, welcome to One on One. My name is Bridget Otu. Today on One on One, there are a number of issues that involve the Supreme Court. And as always, I always want to understand it. And I know if I understand it, and then, because look, I have no legal background, then it means that my viewers and persons who love this show will also get to understand and appreciate what's happening. We will talk about the president's decision not to assent to the anti-LGBTQ plus bill because there's a suit before the Supreme Court. But you know, the statement came out even before that suit was filed, which became a whole issue. We also know of the Member of Parliament for South Dai constituency, Osman Alhassan Esq, who had gone to the Supreme Court again in relation to the appointment of ministers, the approval of ministers. And there was a whole brouhaha about when the case was called, why the case was called, the scheduling of the case, and a whole lot more. Now, that situation has forced the NDC minority in Parliament to say that the Supreme Court Justice Gertrude Tokunum is in bed with government or is adjudicating cases based on government interest. Is that really the case? Is she in bed with government? We will be talking to a private legal practitioner to help us, people like us, to understand what is happening. He's apolitical, so that we appreciate what's happening and then we can take out in the politics bit of it just to help shape the conversation and shape the national dialogue. We'll be right back to meet my guest, lawyer Osman Alhassan. Right, so welcome back to One on One. My guest is private legal practitioner, lawyer Osman Alhassan. Please welcome to One on One.
Thank you.
And thank you for sparing me an hour. I know you're fasting, so thank you. I really appreciate that. It's not easy to
It's
talk.
my pleasure.
Right. I want to start off with the earliest case, which is the Osman Alhassan Esq. I had interviewed the lawyer for him, and he said they were not in court when the case was called. Himself and his client went in court. And he said it is because they were not served notice. Now, I want you to take us back to scheduling the Supreme Court. How does the Supreme Court schedule a case? How do they prioritize? Which case gets to be heard? It doesn't depend on when the case is put before them. What goes into that? I want you to first take us to the basics, and then we'll deal with the details of this case.
Okay. Let me narrow down on the application for injunction.
Sure.
Because the substantive suits has completely different rules governing the time it should be heard.
Okay.
And then when it comes to interlocutory applications, they also have times.
Okay.
And completely different rules governing when they should be heard.
Okay.
Now, if you look at an application for injunction, generally, every application is fixed the date on it before it is served on the other party.
Okay. As in the dates
for hearing.
For hearing, okay.
Every application, generally.
Okay, all right.
I'll come to the changes that I have seen quite recently.
Okay.
Now, if an application is served on the other party, and according to the rules, you have a limited number of days to respond. Now, and the days count from the date you were served. So if you have an application served on you, and then the respondent or the defendant answers the application, then a date, on that date, which is fixed for hearing, it can be determined.
Okay, but please, before you go on, so that means, do I have to respond before the date of the hearing is set? Is there a number of day minimum that should happen before that hearing date, comes on?
Okay. When it comes to an application, generally, we say 3 clear days for the other party to respond. Okay. And 3 clear days here means that the day you were served with the application. Okay. And let me clarify this. Most people confuse the day of filing with the day of service. Okay. You can file a process and it will take a week or 2 weeks for it to get to the person you intended to get to. That's the respondent.
Sure.
And so when you file, the date doesn't count until it is served on the other party. Now, when it's served on the other party now has 3 clear days to respond. Now, 3 clear days means the day on which the person was served is not counted, and the date of the hearing is also not counted. But that is in a situation where already, as I said, generally applications, the date is stated on the motion paper.
Right.
Okay, and usually the registry take into account the number of days it might take to be served and all that, and fix a date. And so when the date comes and you haven't been short served, when we say short service, it means all the 3 clear days are obtained between the time you were served and the date of the hearing. Now, if there's any date short of that, let's say you were served today, tomorrow is the, we say you are short served. So the court can adjourn and give you a further time. In other words, they will still go for the case,
yes, for the hearing,
yes,
but they may not hear it.
Yes.
Okay.
So the other lawyer might say, okay, we were short served, so we need more time to go through the processes.
Sure.
And
I understand.
So that is with applications.
Okay.
But in this particular application, what I've noticed, I just filed an application for supervisory jurisdiction.
Okay.
And unlike what I used to know, it appears now they will serve the other party, and you will conduct a search to know if the other party is served. And 14 days from then, from the service, you now apply for them to fix a date for the hearing.
Okay.
I do not know if this new development has affected an application for injunction. And I must say, I don't know the circumstances under which hearing notice, in that sense, was supposed to be served on the applicant. Because if you apply and it is served, and the respondent responds, and his response is served on you, then of course on the date that is fixed on the motion paper, you both appear and it is determined. Yeah. Now, I want to take, now all this is administrative, and we all know that the administration of justice is under the Chief Justice.
Sure.
No one can do anything administrative within the judiciary without the Chief Justice approval. So if a date is fixed for some cases and some cases are hanging in there, it gives the impression to many people that once the Chief Justice is at the helm of affairs, she is doing some selective
chief administrator, right,
of justice. So, but to be fair to the rules, sometimes when it is filed and it's not served, or the other party hasn't responded, it's still within time to respond, or it might take a long time to be served. In that case, it doesn't matter whether the case is filed first or last. Once the required rules for hearing, for it ripening, have not been satisfied, it can't be heard.
Okay.
Because one important thing in the judicial process is right to be heard. He said you don't condemn someone without giving him an opportunity to be heard. Of course, but that's what we do most of the time. Even lawyers
condemn
do that
before you are guilty,
exactly,
until proven innocent.
Yes. So no matter how obvious a case looks, you don't condemn the person until you hear the person. So it is a cardinal principle within the judicial process, and service is one of such instances or opportunities that's given for you to be heard. So once you are served, now if you are served and the number of days allowed you by the law to respond have elapsed and you haven't responded, then you have been given the opportunity to be heard and you refuse to be heard. at that time, the court can proceed without any further notice to you.
Is that what happened in this case of the Fiamek Paul? Because per the lawyer, they were not served. They didn't get the notice to appear before the court.
Okay.
Both of them. And he said it is not out of disrespect, but because they just were not aware. Again, the case was heard, even in their absence.
Okay. So which means that, so here, I don't know what he was expecting to be served with, but does it mean, I don't know if he was served with the Attorney General's response, or there was a hearing notice issued to be served on them for the hearing, because sometimes, as I have explained...
He said hearing notice. I think he
yes,
spoke to the hearing notice. Yes.
So, for instance, if one is short-served and both of you or one of them was in court, but the one who was short-served was not in court, it means the other one who was short-served would be giving a hearing notice. Whoever is in court will be allowed to apply for a hearing notice to be issued. Now, if it is the court's processes now to issue a hearing notice for service on all parties for an application to be heard, then it means that that hearing notice must be served. It means the court contemplates that both parties have to be present for the case to be heard.
Right.
Though, in most instances, it is held that once it is an application. What's an application? An application goes with a motion paper and an affidavit. And in the case of the Supreme Court for application for injunction, it goes with what we call the statement of case. So the affidavit are the statement of facts that you make in support of the case under oath.
Yeah.
And so that becomes evidence. And then the motion paper now communicates what you want the court to do. You know, the reliefs and all that. Now, the statement of case is the one you argue. So it contains your argument, the law you want to advance to support it, and all that. So all together now becomes what we call the application. So if that is done, if the application is filed and it is served and there is response, and the Supreme Court thinks that, okay, everything you need, we need to hear. Okay. Or everything you need to say in your defense. And
it's already present.
It's already present in writing.
You may not be physically present, but everything else they need on the case is present. Okay.
So they can base their decision or their determination on the consideration of what is filed before them. Of course, there are sometimes they themselves might want you to argue on your feet. And so they will tell you, come on this date, and they will tell you what they want you to address them on point of law. Okay, so in some instances, and it is held sometimes that the judge can hear the matter once the application, all the writings are before him.
So in this case, for instance, I believe the Attorney General mentioned that it was deliberate. They had instructed their staff not to accept any documents. That's how come they were not served. Does that have any influence on how the judges view or on the judge's decision to either hear it or give the plaintiff an opportunity to come in?
Yes. So for me, I think nothing is done in vain.
Sure.
If the court actually issues a hearing notice to be served on the parties, it means that beyond the application and the response and all the writings before them, they require the parties' presence as a necessary incident or condition precedent for the hearing to take place. Okay. And so if that hearing notice is not served, because the service of the hearing notice, as the name connotes, is giving the opportunity to the other person to be heard, come to court and be heard. And so if it is not served, it means that that opportunity is not given.
Sure.
And once you deem it necessary to do that, then you can't proceed with the case until it is served.
Whether the reasons being given are tenable or not?
No, are tenable or not, because it is service. Okay. Service is an opportunity to be heard.
Okay.
And no court, no judicial process will continue unless that opportunity, which is deemed necessary. If you don't deem it necessary, then you don't issue a hearing notice.
But if you deem it necessary and you still go ahead and rule on it, dismiss the case, then it means that it was, or is it that the Attorney General managed to argue in such a way that they felt, okay, they have rather blown that opportunity to be heard in person?
To be honest with you, the instances of this particular, the incidents of this particular case are not things that I am very conversant with, but I'm generally giving you
I understand.
What pertains with the judicial process.
Sure.
You see, so if the lawyer of the Fiamapo was expecting to be served with a hearing notice, and the court deemed it necessary to serve a hearing notice, then for me, I think it was necessary for them to be given some opportunity to be heard.
Sure.
And once it is issued, it has to be served before they can proceed.
Sure.
And if it's not served, in fact, it is a blunder for them to have proceeded to hear the matter without the service of the hearing notice.
So I still want to go with the priority. What then? What's the key factor or determination for a case be called at this time? Does it matter whether mine went first or what goes into it?
Okay, so now I would now like to narrow on the responsibility of the Attorney General.
Okay.
And the fact that just in accordance with his own advice and admonition to Parliament, I overheard something like they are engaging in too much partisan politics. But it appears he himself is not trying to avoid that impression. Now, the Richard Sky case, Richard Sky and the Attorney General, and Dr. Amanda and the Attorney General and the Speaker, both are cases pending. And according to the letter from this President's office to Parliament, they both have applications for injunctions, interlocutory injunctions, directed at the Speaker and the President. Okay? So, if they both have injunctions applications, the question is, why would a later case like the Fiamapo's case be ripe so immediately in time to be heard, but all those are still pending?
Okay.
And I understand that even the case against the e-levy that was filed sometime is still pending to be determined. And we also know how long it took the Domlivo case to be determined. But let me not confound the issues. As I said, we have substantive cases that start with writ and application for injunctions. Now, but let me come back to the application for injunction. Now, the application for injunction will ripe when the Attorney General files his response within the time stipulated. Now, if the Attorney General does not file his response, or let's say it's taking too long administratively within the judiciary to effect service of the processes on the Attorney General. And so there is no, of course, if you are a judge and they bring the file, the first thing you look at before you start to hear is whether there is proof of service. So if there is no proof of service on a docket, then of course you cannot proceed. Now, if there is no proof of service, but there is a response from the other party, then that serves the purpose. It means, of course, if you don't have notice of it, why do you respond? But it is now the duty of the Chief Justice to go as a supervisor, as the administrator of justice, because as we always say, justice delayed is justice denied. Though, of course, justice hurried is justice buried as well. So it's a balance, delicate balance that needs to be struck. And the Chief Justice will have to find out why a particular case is taking too long
to
be served. And at least from the perspective of a citizen with a legitimate expectation of a responsible Chief Justice, that is what should happen. Yeah. And so for those cases to still be pending, because they are the same applications for injunctions, was it served on the Attorney General? Was any time given for the Attorney General to respond? Has the Attorney General responded? Have all the parties responded? And if they have filed their responses, why is it still pending? Okay? Yeah. But, of course, to come into the political implication, of course, we know that the case, the Richard Kai case and Dr. Amanda case, is seeking to restrain Speaker and President from passing a certain law. Yeah. Okay? Now, to be honest, and I have written somewhere that the presidency is not willing to assent to the bill, but it is looking for a reason. And so for me, I see...
That is how come even that statement came out, the statement from the presidency came out before that case was filed.
Exactly. And secondly, what Richard Sky's suit is seeking to restrain the president from doing is assenting to the bill for it to become law. But under the Constitution, the obligation of the president is more than that. You either assent to the bill, or you refuse it, or you transmit it to the Council of State for advice. Okay? So you can do any of these three. What he's seeking to restrain is assenting to it. So if you don't assent, then refuse it, or take it and transmit it.
But in this case, go ahead.
They are also trying to restrain the Speaker from presenting it to the President.
Right.
Okay? Now, it is not the President's prerogative to now be concerned about the Speaker presenting it to him. Because if the Speaker doesn't feel bound by any circumstance to transmit it to you, let him do what he has to do and face his consequence. Yeah. Because the law prescribes what he has to do. And if it is contemptuous, let the Speaker face his contempt. Okay. But you shouldn't be saying that, okay, don't bring it to me because a suit is pending. What is the effect on the suit if the Speaker presents the bill? At worst, it's contempt of court. And if it's contempt of court, is the presidency the culprit? No, because the suit is not restraining the president from receiving the bill. It's restraining the Speaker from presenting it. What the suit is also seeking is to restrain him from signing it. So you can receive it and put it down. Right?
But preventing it at all means that there's already a preconceived agenda.
Now, having said that, as a lawyer, I have my opinion, my position on this, that no constitutional obligation is obstructed by any suit pending in court. Once your obligation is clear from the constitutional provision, and the obligation of the president, as I said, with respect to the passage of a bill into a law, is to assent to the bill and signify that assent to the Speaker, or you refuse to assent to it and signify that refusal to the Speaker. And when you refuse, then you have to now tell the Speaker what within the provision of the bill you want reconsidered. And then you accompany it with recommendation for amendment in a memorandum. If you don't do that, then you have to now take the bill to Council of State for their advice. And if you refuse because you need, and from the provisions of the Constitution, the president cannot just refuse that I won't assent.
Yeah.
The refusal must be based on something within the bill that you need reconsidered.
Sure.
If you don't have anything to be reconsidered and you have no recommendation for amendment, the implication is that you have to assent to it.
Sure.
Now, if you refuse to assent to it and you make recommendations and Parliament reconsider your recommendation or amendment and pass the bill by 2/3 majority, it becomes mandatory. You don't have any discretion anymore not to sign the bill. So these are the obligations. And all in law, when an obligation is conferred by the word shall, it's mandatory. You don't have any discretion over it. You can't say, okay, I choose to do this. No. The law says you shall assent to the bill, shall refuse the bill, and shall do A, B, C. All the obligations of the president under that provision are mandatory.
Okay.
And so if you have a mandatory obligation, you don't have a choice. You can't be willfully undermining a court authority. You don't have the will.
Sure.
It is a constitutional obligation.
Yeah, so I'll just, if you've not seen the president's statement, it says transmission of the Human Sexual Rights and Family Values Bill 2024, and it just says that, it's come to the attention of the presidency that the president and senior officials of the presidency they were in a cabinet meeting and they were made known of this attempt to submit the human rights values bill to the Jubilee House for the president to signify his assent or otherwise. And then he said the presidency or the office is aware of 2 pending applications for an order of interlocutory injunction, both filed on the 7th of March, but that had not happened. That's as of the time the statement was issued, that action had not been taken. So, of course, it made people to question, how did the president get to know? Because it was not done at the time. And that's why there's always that perception of collusion, the presidency, judiciary, which is what the NDC is also accusing the presidency of. So that was the statement. And it says that the Attorney General has, by letter dated 18th March, informed the president that he has been duly served with both applications and has advised the president not to take any step in relation to that. Like I said, it wasn't. So the NDC also said that NDC react to that was the statement they released, that react to probable judicial bias in the scheduling of political cases in the Supreme Court of Ghana. And the NDC statement says they were aware of that decision by the Chief Justice of Ghana to list the case, which was the Roxanne Dafiamepo versus the Speaker of Parliament and Attorney General, for hearing, which came on the 27th of March 2024. It says the NDC is intrigued by the listing of the Dafiamepo case for hearing ahead of the case of Richard Delasky versus Parliament of Ghana and Attorney General. So they're all linked here. Because they don't understand how is that not a priority? And ours is. And this one came before ours. Okay? So it's interesting to know that Richard Sky filed his writ of summons in the Supreme Court, challenging the constitutionality of the Sexual Rights and Family Values Bill on the 5th of March 2024. This was almost 2 weeks clear before Honorable Roxanne Dafiamepo filed his writ of summons on the 18th of March 2024, challenging the constitutionality of the latest ministerial nominations by the president. Given the recent political deadlock that the 2 legal suits have created between the executive arm and the legislative arm of government, one would have expected that the date of filing of the cases would have informed the timing of their hearing by the apex court. Yet, for some strange reasons, the case of Honorable Roxanne Dafiamepo, which was last in time to be filed, has hurriedly listed, it means it's gone up, right ahead of the Richard Sky. It says it's quite apparent that this is a ploy by the Chief Justice to fast-track the determination of the suit filed by Dafiamepo, while the determination of the Sky suit is deliberately and unduly delayed to enable the president to shelve the crucial Sexual Rights and Family Values Bill that has been passed by Parliament. Even more bizarre, concluding paragraph, is the fact that the case filed by some NDC members of parliament challenging the constitutionality of the passage of the electronic transaction levy as far back as 2022 has not been listed for hearing by the Supreme Court. So this is the dichotomy. This is the issue. They said the president did not hold back when it came to e-levy.
Yes.
Same private members bill assented to it, whether there was a case before the Supreme Court or not. So because of that, they think they are biased and they are unhappy with it. Are they justified in their claim?
Yes. So if you look, for me, I think this claim and impression, and I always say that, look, realities are not the only things we should be afraid of.
Yeah.
Perceptions are also as dangerous as such.
Yeah.
So if you create an impression, because if two cases in relation to one political matter are filed, or in relation to the same principle are filed, and one is heard, the later one is heard first.
Yeah.
I think the Chief Justice owes the public the responsibility to find a way of explaining why that has happened.
Sure.
Because we know how, as lawyers, we know how the judicial process works. Now, there must be some application. I hear there was some application by the Attorney General for abridgment of time. I don't know how true that is. But that actually explains why there will be the need for service of a hearing notice.
Yeah.
Because which means that the date that was fixed on the application for the injunction was truncated, was reduced, was brought back. So if the date is changed from what the applicants knew, then it means it became necessary for the applicants to be served with a hearing notice telling them that, okay, the date has been brought back. That's the only reason I can contemplate as forming the basis of the
Other than that, it would make no sense.
It would make no sense for such an for a hearing notice to be an incident for such a situation.
Is there a reason why the e-levy one hasn't come up? It's not even listed.
Well, that's why I'm saying that. So all these things are legitimate questions that citizens can ask about the judiciary. But no doubt it creates the impression that you are selective with the cases that you hear. And we all know that even the Domlevo case was heard long after the decision that the suit was seeking to prevent had happened. So for people to have that impression is in itself not good. But I think that impression is finding legitimate grounds. Why would you allow cases that were filed earlier not to be heard? If, and I'm saying this, if all the conditions precedent for determination of those cases have been satisfied, because why would an application for injunction penned since 5th of January till date? And that's the Richard Sky one. Why would an application for injunction penned, I think, from the 17th or 7th of February, if I'm right, the Dr. Amanda one.
Okay. Well, I thought it was March.
It was March.
I think so. Yeah.
So an application, a motion for injunction is pending till now. And I think that one was determined, and the Supreme Court decided that, okay, they don't have the power to hold Parliament from proceeding. And that became a reason why I said that no pending issue can prevent the performance of a constitutional obligation.
Okay.
But if you look at the politics of the cases, now the understanding is that because of the pendency of the application for injunction, it will be an undermination, or it will be prejudicial to the determination of the suit and a disrespect to the Supreme Court for anything to be done. And so with that understanding, they say, okay, let's determine the application for injunction quick and dismiss it. So it will not be a reason for the Speaker, who is retaliating the action of the President, not to consider the approval of the ministers of the President. Okay. But the one which is holding the President from signing, let's let it pend. You see the impression? Sure. This is the impression that is created. Yeah. That the one that is holding the president, we won't determine it, because if we determine that, the president will have no reason to hold on to the signature of the bill.
Okay, we will have to take a break. I think my final question on it will be about the executive and the legislature, where we are. I mean, it's not the entire, we know it's the Speaker of Parliament who said that, look, me too, I'll flex my muscle. What's the implications of that, that kind of, fight among elephants? After the break, and then we'll look at Imani Ghana's suits to prevent future president from removing public officers. First, they had zoomed in on security agencies, but when pressed further in an interview, they said, look, it involves all other public officers. Is our constitution already catering to that? After the break, we'll find out. Welcome back to One on One, and my guest is lawyer Osman Alhassan, and we've been talking about the anti-LGBTQ plus bill, the president's decision not to sign. And he says, in my lay understanding, my basic understanding of it is that nothing prevents the president from receiving it. The suit says we will prevent you from assenting to it, so it becomes a law. Because of the those who are challenging this, I say, because of the dire human rights consequences for persons within the LGBTQ plus community. So the president can receive it and say, okay, I'm not signing, I'm refusing, or I'm refusing to sign. But nothing prevents him from saying Parliament should not bring the bill. That's my understanding of it. But the implications of that, the Speaker saying that, look, the Speaker is number 3, right? If we're doing ranking,
yes.
President,
yes.
Vice, and then the Speaker
yes.
is number 3.
Yes.
So a potential president.
And he's very proud of it.
And he is proud. He says that proudly, right? And in this case, there are egos. It looks like there are egos at play. What's the implications of that? What the Speaker is doing, saying that, look, I also have the powers to block your ministers.
Okay.
Yeah, what's the implication?
You see, let me say that the Speaker's posture or posturing is a reaction.
Okay.
I know the Speaker will not do that.
Okay.
But it's a reaction that is supposed to communicate the effect of the president's actions. Or in terms of generalizing the president's action, the principle that the president is espousing, that as soon as an action is filed, and an application for injunction seeking to restrain me from performing my constitutional obligation is pending, then I have to hold on to that constitutional obligation until the suit is determined. I wrote somewhere that if you make this the law, government business will run to a halt. And that is why when we are even challenging the validity of the president's election, he's still performing the functions of a president.
Right.
Now, imagine that someone files a suit challenging the competence of the president and follows it with an application for injunction against the president to restrain him from performing any function of the president until the suit is determined.
Yeah.
Then you make the law as judiciary that, okay, once that is pending, president, stop performing as a president. What do we have? The business of government will run to a halt. And that's why I say that when it comes to constitutional obligations, no pending suit is sufficient to hold it because it must be treated as binding until an order, express order
from the court,
from a competent court, say no, suspend it. And that must be done based on nobler constitutional reasons, because the court cannot do that. If you don't do that, and then you say, okay, anytime there is a pending, so I'm trying to let you understand why the Speaker is doing what he's doing. So the Speaker, in the same vein, said, okay, I'm going to apply your own principle. You've brought us ministers for approval. Now, someone has taken an action in the Supreme Court challenging your assignment of certain ministers whom you have removed from office to new offices. And so the person asks for an injunction. And let me say that even understanding an injunction only to be the one that is interlocutory, I think the Attorney General and the President are understanding the only thing that can hold them is an interlocutory injunction. But injunction is an injunction, because if they ask a perpetual injunction within the relief, which will come after the determination of the suit, okay, that is also an injunction to be determined.
Yeah.
Okay, so you can't say that, okay, once an interlocutory application pending can prevent me from exercising or performing my function, my obligation, my constitutional obligation, but a perpetual injunction, which is part of the relief, cannot prevent me from performing my function until it is determined. Now, I will make the distinction between the interlocutory and perpetual injunction. Okay. Usually, the interlocutory injunction is done by a motion, an application, an affidavit, that, as I explained. They file it, and it is seeking to stop action, maintain the status quo until the final determination of the suit. Now, a perpetual injunction is made part of the reliefs of the substantive suit itself, which will come at the end and say, henceforth, don't do this forever.
Forever.
You see?
Yes.
So, either way, if the injunction application is pending, or it is a relief in the substantive suit, it is still pending. So you can't say that once we have determined the interlocutory application, then the speaker can proceed, because there is a relief which is substantive within the writ itself, seeking perpetual injunction against him. He can still say, okay, I'm waiting for the Supreme Court to determine that perpetual injunction, because if I take any action, I'll be prejudicial to the and so what do we have? And so that is the turf war that's going on between, and the implication is dire, because, to be honest, this is the first time, and I say it's unfortunate that it's happening in the reign of a lawyer, because these are constitutional blunders. And I find it very, very, very worrying that some of our colleagues of very appreciable repute are lending credence to the fact that a constitutional obligation should be withheld just because a suit is pending. No, the only thing that can stop
but that is politically motivated.
That is politically motivated. And you can see that each one is using the antics of litigation to pursue an ulterior motive, a motive that is ulterior to the constitutional purpose.
Okay. Lawyer, I mean, look, I love having lawyers, man, because I get to learn a lot. But we must touch on the Imani suits that they are in court, and I had spoken to you off air about this, not here, but on news.
Yes.
To when I was going to speak to Imani Ghana, and you said they were dealing with the 191. Article 191 of the Constitution, where it talks about the president's powers to appoint. Correct?
Yes.
And I think you said they should look at, is it 201 or 205?
Yes, I was talking about.
So they are in court. Well, you look at, so Imani is in court saying that, look, future presidents should not have the powers to remove public officers. They cited police, prisons, immigration, that they don't move the heads of those institutions simply because they want to move them, unless maybe they are of retirement age or they are physically incapable of being in that office and running it, or not maybe mentally sound, let me put it like that. But not that, look, somebody comes in and then removes Madame Charlotte Osei from the Electoral Commission's office with no basis because they can. Somebody removes, the president removes Domilevo as the Auditor General, because he was looking into cases that made government look terrible because of the rots in that in various institutions, under this government. So that's essentially what it is.
And Martin Amidu was compelled to resign.
And Martin Amidu, like that, who was at the office of the special prosecutor, yes, forced to resign. And he, before he left office, called the president the mother serpent of corruption. That was one of the most famous, brilliant sentences or phrases that he left the office with. So Is this suit really justified? Is it not catered for in the Constitution that the president can appoint and remove?
But let's first deal with what occasioned this suit.
Yes, I asked that.
Yes. What occasioned this suit? Now, and let people understand that the Supreme Court is not a place you go for legal opinion. They don't, their jurisdiction to interpret the law is not invoked in vacuum. There must be something that someone has done or some law that has been passed. Then you challenge that conduct or that law.
Sure.
Now, if in determining whether the conduct is constitutional or not, the Supreme Court deem it necessary to interpret the constitutional provisions, then they will interpret. But you don't, so the question is, what are you seeking to declare unconstitutional? Has some president removed some officers and you think that, okay, that conduct is unconstitutional? Now, the Supreme Court jurisdiction, original jurisdiction, to deal with enforcement of the Constitution and interpretation of the Constitution is coming from Article 2. And Article 2 is clear about what should happen before you approach the Supreme Court. It said, any person at all, and here person refers to a citizen of Ghana, who alleges, listen, there must be an allegation, who alleges that someone's conduct, an act of a person is inconsistent or contravenes a certain provision of the Constitution, or you allege that a certain law passed by Parliament is in excess of the powers of Parliament, then you can go to the Supreme Court for a declaration to the effect that the person's actions or conduct is inconsistent with the Constitution. Now, and when you do so, you must itemize the conduct, and then you match it against the constitutional provisions it is violating. So here, under Article 2, before you go to the Supreme Court, you are going to find out whether certain conduct violate the Constitution. So here, the way I look at the Imani suit, it looks more like a suit that is asking for a prior opinion of the Supreme Court that would be the basis for judging or for dealing with future presidents who are yet to come.
But so let me walk in their minds, to be fair to them. So say we've heard of the IGP, George Ekufu Dampari, for instance, that there were rumors that he could be removed, and people are wondering, what has he done? The action hasn't happened yet. But what about Charlotte Osei? What about Domilevo? Are these not actions that could have been prevented? I mean, at a point, Domilevo's office was locked. He couldn't go to his office. So are they not examples good enough?
And that was a clear violation of the constitutional provision, actually.
Is that not clear enough? So those are examples that are there.
Yes, well,
I think they mentioned COP upon Bueni that he wasn't even up to 60 and he was removed.
Yes, but what I'm trying to say is that this suit seemed to be a suit in vacuum. Because nothing has happened that you are seeking the declaration of the Supreme Court that what has happened is unconstitutional.
So all these were done,
because when I look
they
at
use the constitutional provisions, so all these are justified.
Yeah, so you see, in Charlotte Osei case or in Domilevo case, something has happened. The removal of Charlotte Osei. So you are going to the Supreme Court to say that the removal of the former Electoral Commission chairperson, which is a conduct, an act of the president, is inconsistent with certain provisions of the Constitution. Or you go to the court and say, okay, the removal of...
Oh, I get you.
So if
what
there is
they are doing is there's like a general future or something. Okay, now I get it. Okay,
exactly.
now I understand.
So
okay.
if there is
Makes
no
sense.
instant, there is no action to be declared as unconstitutional, why do you go to the Supreme Court? You cannot just couch a
based
relief
on past events.
Okay, based on
we
past events or even abstract events.
Sure.
That we want the Supreme Court to tell us whether or not this can happen. No, the Supreme Court...
Or it shouldn't happen again. Prevent somebody from doing it. Future
no, if it has happened, of course. If it has happened. So I believe that that suit will suffer a lot at the stage of jurisdictional claims. But definitely, the other parties will challenge the jurisdiction of the Supreme Court to even hear it, because there is nothing.
Okay.
There is nothing that has happened. So if, for instance, if this president had removed some police personnel or armed
that's why they
forces.
mentioned COP upon Bueno, that he wasn't 60 and he was removed. I mean, they mentioned
COP what?
Upon Bueno. He was IGP for
And so he's been removed.
Yes, he's
so is it? So they are saying that he's removal. Okay.
Yes. So they've cited such examples.
Okay. Instances.
Yes.
Okay.
So they have a chance.
You say ACP what?
COP Upon Bueno. I know him very. I worked with him.
And he's been removed from office.
Yes. I thought he was due for retirement, but according to Imani, he wasn't due for retirement, and he was removed, even though he hadn't done anything. So, and I think the whole suspicion that George Ekufu-Dampare could be removed as well. So they're anticipating that it shouldn't happen unless they are fiscally.
So in that case, I think
they have a point.
It's right.
Okay.
So because there's now something that they are, and on the back of that, they are saying that you don't have the competence or the authority to even do that because of this provision of the Constitution, this provision of the Constitution. In that case, I think the suit is proper.
Osman Alhassan is a private legal practitioner. I always enjoy when you come on the show because I get to learn a lot, and I know my viewers also get to learn a lot. And appreciate your time and your resource. So thank you again for coming on 101. I hope you've learned a lot. Go to all our social media platforms on Twitter, Facebook, and leave your comments there. Yeah, let me know if you learned a thing or two and if you appreciate what happened at the Supreme Court, if you follow it. So that when you hear the cases being mentioned, when you hear the issues being discussed, you understand the basis on which, and when they are political, as some, based on what the lawyer's interpretation of the Constitution is, show that indeed there are political decisions and not constitutional decisions. My name is Bridget Otsu. See you again next week.